Madam Clerk, it is 7 o'clock. I'm going to call this public planning meeting to order. Okay, a motion to approve the agenda. Councillor Gallo, second by Councillor Thompson. Any comments or questions? Seeing none, call the vote. That carries. Any declarations of pecuniary interest? Seeing none. I'll read my public planning meeting statement. So welcome to Aurora's public planning meeting. The purpose of this public meeting is to inform the public and obtain public input regarding the proposed zoning bylaw amendment. For the planning application that will be considered by council tonight, the following process will occur. 1, town planning staff will outline the purpose of the planning application being considered. 2, then the applicant will be given an opportunity to make a presentation and address issues raised in the staff report or public concerns already filed. 3, following these presentations, members of the public will be invited to offer their comments or concerns respecting the proposal. And 4, either town staff or the applicant will answer your questions. I will keep track of the questions, and when I have several, I will direct them to whoever can best answer them. It is very important that the town receive the correct names and addresses of individuals having an interest in the planning application. Therefore, if you plan to speak to council at this meeting, or if you wish to be notified of any further council or committee meetings concerning the application being considered, you must complete one of the green interested party forms being held up and give it to our committee coordinator sitting at the front. Under the Planning Act, the applicant or residents have the right to appeal any decision of council on a planning application to the local planning appeal tribunal. But you must verbally express any comments or concerns here tonight, or submit any comments or concerns in writing to the town prior to council adopting an amendment. The tribunal may dismiss all or part of an appeal made in respect of an application. This public meeting is being audio and video recorded. Your name, address, comments, and any other personal information are being recorded according to the Municipal Act and the Municipal Freedom of Information and Protection of Privacy Act. This will help our town clerk prepare accurate minutes to create a record that is available to the general public, including the town's website. Questions about this collection should be directed to the town clerk, Town of Aurora. I will now ask the Deputy Town Clerk to confirm that notification to the public occurred as required by the Planning Act.
Thank you, Mr. Mayor. Respecting item 1, PDS 19-082, application for zoning bylaw amendment, Morgan Planning, 2 Willow Farm Lane, file number ZBA-2019-02. On September 5th, 2019, a notice of complete application and public planning meeting were published in the Aurora Banner and Aurora newspapers and mailed to all addressed property owners within a minimum of 120 meters of the subject lands. Also, on August 27th, 2019, 2 notice of public planning meeting signs were posted on the subject lands fronting Willow Farm Lane and St. John Side Road West. Public notification has been provided in accordance with the Planning Act.
Thank you. I will now ask the Director of Planning and Development Services to begin with the presentations.
Thank you, Mr. Mayor. Initially, we'll have the applicant's consultant do a presentation, followed by Sean LaPena, the development planner for the town, would also be making a presentation following the consultant's presentation.
Thank you, Mr. Waters.
Good evening. My name is Josh Morgan. I'm a registered professional planner. Okay, my apologies. My name is Josh Morgan. I'm a registered professional planner. Is that better? Okay. I'm here today representing the owner of 2 Willow Farm Lane, Mr. Jeffrey Allen. Mr. Allen contacted me more than a year ago and asked me to assess whether I felt that a severance of his property was viable, and after doing so, I took the position that I felt that a severance was viable and was supported by all of the relevant planning policies, and went forward and pre-consulted with the Conservation Authority, the Region of York, and also with the Development Services Committee at the Town of Aurora. and we submitted a zoning bylaw amendment application in mid-June of this past year. The subject property is shown basically in the middle of your screen here. It's at the northeast corner of St. John's Side Road and Willow Farm Lane. I think what I'll do to start here is just basically walk you through some images of the exterior of the subject property. So this property here, or sorry, this picture here is facing due westward right into the driveway of the subject property. And this next picture is looking northward towards St. John's Side Road. So the subject property is on the left-hand side of the screen here. You'll see the gate feature on the left and the driveway on the left-hand side leading into the subject property. This picture is a flip of the one before. It's essentially looking straight due south down Willow Farm Lane. And this property is taken from St. John's Side Road looking southwest. So this is essentially the entire northern periphery of the subject property. You can see it's well treed along its boundaries. And I'll get into some more details about the property here going forward. So what you see on the screen right now is just the original plan of subdivision, which illustrates the subject property as Lot 86. You'll see it's a rather irregular shaped lot. As I'll get into further on in my presentation, the western periphery of the lot is designated by the Town of Aurora's official plan as estate residential, whereas the small portion of the property in the northeast corner, right at the corner there, is designated stable neighborhood. So there's a split designation which applies to the property. This image on the right-hand side just more zooms in on the property so that you can understand the relationship of the lot fabric of the subject property with the adjacent lands. So as I mentioned, the property is at the southwest corner of St. John's Side Road and Willow Farm Lane. The entrance feature for the subdivision, which I believe is called St. Andrews Hills, is right on the northeast corner of the subject property. The property is developed with a single dwelling, which is accessed from Willow Farm Lane, as was evidenced in the earlier pictures. My client, Mr. Allen, and his partner live at 2 Willow Farm Lane. The property has 107 meters of frontage onto St. John's Side Road and 22 meters of frontage onto Willow Farm Lane. The area of the property is 1 hectare, or about 2.5 acres. And as you'll see on the image on the right-hand side of the screen, the yellow band there illustrates an area that is regulated by the Lake Simcoe Region Conservation Authority. So on the left-hand side here is just, and Mr. LaPena, I'm sure we'll go through this, so I'll be brief. On the left-hand side of your screen is an excerpt from the Town of Aurora's official plan, the land use schedule from the official plan. The sort of beigey pink color is the estate residential designation, and the yellow color is the stable neighborhood designation. So again, there's a split designation which applies to the property. And on the right-hand side of your screen, this is an excerpt from the Town of Aurora's zoning bylaw. The entirety of the subject property is zoned Estate Residential Exception 73 zone. So as you'll see, the property to the west or to the left of the subject lands is also in an estate residential zone. The properties along St. John's Side Road, some of them are also in an estate residential zone, but the properties to the southeast of the subject properties are all zoned Residential 2 Exception 74 zone. So moving into what the purpose of this hearing is tonight, the purpose of this hearing is to rezone a proposed severed parcel from estate residential exception 73 zone to the R2 exception 74 zone. The proposed zoning bylaw amendment would enable a future lot severance at the northeast corner of the subject property. So the lands, I understand that you're not here to consider the severance per se tonight, but the zoning bylaw amendment application would facilitate a future severance application. So ultimately, the proposed severance is to sever the lands that are designated stable neighborhood and leave the retained lands, all of the retained lands would be those lands that are designated estate residential. So ultimately, the purpose here is to sever the land in accordance with the split official plan designations which apply to the subject property. The proposed severance has been designed so that the severed parcel meets each of the performance standards of the R274 zone, and that the retained parcel meets each of the performance standards of the ER73 zone. So we crafted the proposed severance so that all of the performance standards of each of the two zones would be met. And the proposed severance would result in 2 residential lots of similar size and shape to the adjacent lands. And that's evident on the screen on your right-hand side here. The properties immediately south of the proposed severed lot are all zoned R2-74 and are similar in size and shape to the proposed severed parcel. The retained lands are similar in size and shape to the estate residential lot to its immediate west. So we're obviously seeking to achieve compatibility here and maintain the character of the existing community. I won't get into all of the numbers and details here. I've got 2 zone matrices. This zone matrix before you illustrates, it relates to the proposed retained parcel, which this zoning amendment application does not relate to the proposed retained parcel. It only relates to the proposed severed parcel. So the retained parcel is proposed stays in the ER73 zone, and the left-hand column here outlines all of the performance standards of the ER73 zone. The middle column outlines the proposed performance standards of the retained parcel, and the right-hand column simply illustrates that each of the performance standards of the estate residential 73 zone would be achieved through the proposed severance. This next slide is a zone matrix that pertains specifically to the severed parcel, which we're proposing to rezone to the R274 zone, which is consistent with those lands immediately to the south. And what we're seeking to illustrate here is that the proposed severed parcel meets each of the performance standards of the R274 zone. So just a quick overview of provincial and regional planning policy here. So obviously we have to have regard for the provincial policy statement. We also have to have regard for the growth plan for the Greater Golden Horseshoe, and of course the York Region official plan. So it's my opinion as a registered professional planner that the zoning bylaw amendment before you here this evening meets the intent of the provincial policy statement for the following reasons. And I know that these are all big, broad brush policies, so it's, it sometimes seems a bit of a stretch to apply them to very specific applications, and I'm happy to answer your questions if they come up from a policy perspective, but the proposed lot creation and the zoning bylaw amendment that you're here to consider this evening would facilitate the creation of 1 new infill lot within a serviced urban area. Municipal, sanitary, and water service are available to the property line, and the Lake Simcoe Region Conservation Authority has expressed no concerns with the application, thereby confirming that the proposal would not impact any significant or sensitive environmental areas. And each of these comments that I've made as they relate to the provincial policy statement would also apply to the growth plan for the Greater Golden Horseshoe, now referred to as a place to grow. In terms of the York Region official plan, it's also my opinion that the zoning bylaw amendment meets the intent of the York Region official plan. The York Region OP requires that a minimum of 40% of all residential development occur within the built-up area. This, of course, is within the service built-up area. The creation of 1 new infill lot within the built-up area assists with the intensification objectives of the York Region official plan. And it's important to note that York Region has expressed no objections to the application, nor have they expressed any objections related to a future entrance onto St. John Side Road that would service the retained parcel. That was one of the very first things that we did here, is communicate with York Region to determine if an entrance permit onto the regional road would be acceptable, and they have confirmed for us, although we still must submit a permit application, of course, they have confirmed with us that they have no concern with a future entrance onto St. John Side Road. Excuse me. And just turning the policy analysis to the Town of Aurora's official plan, it's my opinion as a registered professional planner that the proposed zoning bylaw amendment, and ultimately, I hope, the severance application would meet the intent and objectives of the Town of Aurora's official plan for the following reasons. First of all, the proposal would qualify as minor infilling in an existing urban area, which is permitted by Official Plan Section 15.211. Both the proposed severed and retained lots are very similar in size to the existing lots which are adjacent to them. Therefore, it's felt that both of those lots, the severed and retained, would maintain the character and the integrity of the existing neighborhood. A lot of the severance tests in the town's official plan, which is pretty standard in municipal official plans, of course, is to consider compatibility of any planning application. And it's my opinion, based on the fact that the severed lot and the proposed severed lot and the proposed retained lot are very similar in size and shape to their adjacent lots, that in fact compatibility would be achieved here. The proposed R274 zone, which would apply strictly to this proposed severed parcel, is consistent with the adjacent lots that front onto Willow Farm Lane and the neighboring lots which front onto Heatherfield Lane. And as I've mentioned previously, both the proposed severed parcel and the proposed retained parcel have been designed to meet each of the performance standards of the zones which apply to them, okay? The ER73 zone and the proposed R274 zone. So just to summarize, we've had extensive pre-consultations. The Conservation Authority has expressed no concerns. York Region has expressed no concerns. I understand that there was one letter of support from, I think, the owner of 1 Willow Farm Lane, which is immediately across the street. One letter of support from that property owner was submitted. I think that there was a letter of concern or perhaps a letter of opposition from someone in the neighborhood concerned with impact on property values. But I believe that what we're proposing is entirely reasonable. I believe it's supported by provincial policy, by regional policy, and also by the town's official plan policies. And I'd be happy to answer any of your questions. Thank you.
Thank you. Sean?
Good evening, everybody. Welcome to the statutory public planning meeting for zoning bylaw amendment application ZBA-2019-02. A zoning bylaw amendment application has been submitted in order to facilitate a future land severance at the property in order to create one additional single detached dwelling lot. The applicant is proposing to rezone a portion of the subject lands from ER Estate Residential Exception Zone 73 to R2 Detached Second Density Residential Exception Zone 74 under the town's zoning bylaw. The subject lands are currently comprised of one parcel and is located on the southwest corner of St. John's Side Road West and Willow Farm Lane. The proposed application will be reviewed for consistencies with the following provincial, regional, and municipal policies: the provincial policy statement, the growth plan for the Greater Golden Horseshoe, the Lake Simcoe Protection Plan, the York Region's official plan, the town's official plan, the town's zoning bylaw, and other applicable municipal plans and bylaws. As previously mentioned, 2 separate official plan designations currently apply to the subject lands. The majority of the lot is designated estate residential in pink, while a smaller portion of the lot towards the northeast of the property is designated stable neighborhoods, shown in yellow. The rezoning is intended to apply to the stable neighborhood portion of the property only. The subject lands are currently zoned ER Estate Residential Exception Zone 73 under the town's zoning bylaw. This zoning primarily allows for detached dwellings, second suites, and home occupations. The site-specific zoning exception number in place requires a minimum lot area of 4,000 square meters, as well as a minimum lot frontage of 34 meters. The size of the newly proposed lot, the lot area for the severed portion, would no longer be considered an estate residential property, therefore requiring a zoning bylaw amendment in order to accommodate the future severance proposed. The applicant is proposing to rezone a portion of the subject lands from ER Estate Residential Exception Zone 73 to R2 Detached Second Density Residential Zone 74. The R2 detached second density residential exception zone, 74, is a site-specific form of zoning which already exists under the town's zoning bylaw. Further to this, the R274 zoning is in force and applies to adjacent neighboring properties to the south and to the east of the subject property. The proposed zoning bylaw amendment would allow the owner to submit a future subsequent consent application in order to facilitate a future land severance at the property to create one additional single detached dwelling lot, in addition to keeping the existing estate residential dwelling on the lot to be retained. The newly created lot would accommodate a new single detached dwelling fronting onto Willow Farm Lane. The newly proposed lot would have a minimum frontage of 22 meters and a minimum lot area of 950 square meters, meeting the R274 zoning standards. No variances have been requested, and the proposal as currently shown meets the R274 zoning requirements. A first submission has been circulated and reviewed. The following are matters that require further discussion: overall suitability and appropriateness of the proposed development, compatibility of proposed lotting pattern compared to immediate surrounding area, zoning provisions, site servicing and grading, tree protection, site access for both the retained and severed portion of the subject property, cash in lieu of parkland. Planning staff's summarized comments from the public received to date are as follows: concern about how this development will affect property values, no concerns regarding the zoning bylaw amendment application. Staff will undertake a technical review of the subject application addressing the outlined matters, as well as the comments received from the public and council raised at this evening's meeting. A comprehensive report with recommendations and options will be presented for consideration and direction at a future general committee meeting. The applicant is available to answer any questions, should you have any. Thank you.
Thank you, Sean. I will now ask if there are any members of the public that would like to speak. Seeing none, I will close this the public portion of this meeting. Council, I'll ask if any of you have any questions for the applicant at this time. Not staff yet, just to the applicant. We'll get to the report right after. Seeing none? Okay. Well, then we'll move to item number 1. Someone like to put a motion on the floor? Councillor Gilliland? Move the recommendation. Thank you. Second, Councillor Kim. Comments or questions? Councillor Gallo.
Thank you, Mr. Mayor. Just for my own edification, if the point of this is to eventually go to a consent application for a severance, is there a reason why we're not doing this all at once? And is there any ramifications, I guess, if we do this and not have the severance?
Mr. Waters?
Through you, Mr. Mayor, I believe the approach that's being followed by the applicant is a proper approach. You wouldn't combine the rezoning and the severance together because it's two different decision bodies at the end of the day, and it would not predetermine the severance. It would have to be evaluated on its own merits, and it's typical for properties to have split zonings.
So through you, Mr. Mayor, when would we expect the severance to come back? And
Councillor, I believe the severance is a C of A. It's
So
a
it
C
won't
of A
even-
decision. We won't see a severance, and that's why we're not dealing with it, because it's two different bodies that
I
would
see.
be dealing with the issues.
So should they not proceed? I mean, I don't know why they wouldn't, but let's say this moves forward and it gets approved. Is there any ramifications if the zoning is changed and I guess you already answered it, that it's common to have two different zonings on a single property?
Mr. Waters?
Through you, Mr. Mayor, as I said, split zoning is common, but it's still one ownership, and I suspect that the zoning bylaw only permits one single-family dwelling on the entire property.
Do we know, through you, Mr. Mayor, if this was the original intent of this law? Because it seems like it's the natural progression of what should have happened, or do we know the history and if this is what
Maybe it's something that we could all kind of like delve into and look at.
Yeah.
But yeah, I don't think anyone has the full history of that lot. But I agree with you. I think it just looks like that's the way it should be.
Yeah.
And considering it is a split zone right now, it was probably contemplated.
And the other question, in terms of driveways, so I heard that York Region does not have an issue with adding a driveway on St. John's. So is the intent for the existing property to have access from St. John's and this new one off of Willow Lane? Is that the intent?
Mr. Waters?
Through you, Mr. Mayor, that is my understanding that the region has confirmed that access will be available off of St. John's Side Road. I can't tell you where the access will be. I haven't seen the details, but they have confirmed that access will be available.
And those decisions will be made by the Committee of Adjustment in terms of those details, as well as I noticed that there's an easement along the north property line of the next property to the south of the Severance property. Is that for a potential driveway for the existing home, or not that it matters in this case, but I noticed that there.
Mr. Waters?
Through you, Mr. Mayor, through the C of A process, those types of details will be confirmed in terms of any easements that need to be identified, access arrangements as well.
Councilor?
That's it. Thank you.
Any other comments or questions? None. I just have one, Mr. Waters. Would we be seeing once it gets to a site plan? Would this council be seeing a site plan application?
Through you, Mr. Mayor, a consent application would be required, and staff would need to confirm if there would be a site plan application required in addition to that.
Mr. Waters?
Through you, Mr. Mayor, through the consent application, we would ask the applicant to provide elevations for the new dwelling.
And council would see that at some point, or would it be something that would be dealt with internally?
It'll be dealt with internally, Mr. Mayor. There's no site plan for this property.
Okay, thank you. Any other comments or questions? Councilor Gallagher?
Just to be clear, the next time we'll see this is at a general committee, and many of the questions that are outstanding would be in that, but no details in terms of site plan or the potential.
Well, I'll let Mr. Waters, but I'm thinking that there'd still be no severance by the time it comes back to us. It still wouldn't have gone to the Committee of Adjustment. There would still be no application as far as building another dwelling or anything. So we would just have what we have in front of us right now.
So the severance is contingent upon us making a decision first. After we've made a decision on the zoning, then it would go to the Committee of Adjustment?
Mr. Waters?
Through you, Mr. Mayor, I believe that's the process they are following, yes. So rezoning first and then severance. The rezoning process can take much more time than the severance, and typically severances do have sunset clauses in them. So I believe the approach here is to move forward with the rezoning first and then have the severance process afterwards.
And through you, Mr. Mayor, the site plan wouldn't come to us because they're not asking for any variances to that bylaw that we're proposing. The setbacks and all of that are in line with the, is that why?
Mr. Waters?
Through you, Mr. Mayor, this is not a site plan control area.
And I get
No,
exactly
but
what you're saying, yeah.
If they were asking for any variances in terms of setbacks, wouldn't that come to us at a site plan stage?
So, Mr.
because
so
they're
Mr.
not-
Waters, if once, and I'm with you, Counselor, if once this is approved, and then if a severance is approved, and then they come with an application to build a home
That's
which
higher
needs-
than our
which is higher,
bylaws,
which
that-
needs some variances,
Yeah.
would we see a site plan at that point coming in? No, that would still fall under a C of A, and they would deal with it, and council would not deal with that.
Okay.
Okay. Any other comments or questions? Seeing none, call the vote. That carries. Confirming bylaw. Mover? Counselor Gallo, Counselor Gilliland. Comments, questions? None. Call the vote. That carries. Motion to adjourn. Counselor Gilliland, Counselor Kim, all those in favor? Opposed? That carries. We are adjourned. Thank you very much, everyone.